What does a feminist say when a highly publicized sexual assault trial ends in acquittal for the accused? Well, the script is as predictable as the pious platitudes one would find at a women's conference on decolonizing and indigenizing a lesbian poetics of resistance. And if you think that's an exaggeration, you don't know academia like I know academia. But that's not my subject on today's Flamingo File. I'm Janice Flamingo of the University of Ottawa. 2 weeks ago, after a sensational case that dragged on for more than 4 years and ruined many young men's career dreams through the suspension of the entire varsity team, 2 University of Ottawa hockey players were found not guilty of sexual assault. And at least one of the feminist activists who used the case to advance an anti-male agenda couldn't care less about the men involved. This case shares similarities with a number of other high-profile sexual assault trials involving a drunken hookup, a story that changed over time, and an accuser caught lying on the witness stand. It's a complicated case and one that has not been reported extensively, but in brief, the accuser arranged a date with a varsity hockey player while the University of Ottawa team was in Thunder Bay, Ontario for a game. After drinking and partying together, the accuser and the hockey player had sex in his hotel room. There was a lot of drunken partying going on at the hotel, with members of the team coming in and out of the hotel room while these two were having sex. Not something I would recommend to any of my friends, male or female, but nothing remotely illegal. Things got more complicated when a second hockey player, the roommate of the first man, approached the woman for sex, and she did not object. There's a discrepancy in the testimony as to whether she verbally consented or not. Certainly, she never said no. She had sex with the second man, and then she left. After the incident, with the encouragement of a friend of hers to whom she may have claimed to have been victimized in order to cover her embarrassment at what she'd done, she agreed to press charges against the second hockey player, claiming that she was pressured into sex with him and had never consented. She also pressed charges against a third teammate, though he testified that he never touched her, having entered the hotel room only as part of a drunken prank. In the verdict, the female judge, Ontario Justice Chantal Brochu, found that the accuser had not given a reliable account to police, changing her story frequently, and had demonstrably lied in court, thus seriously weakening her credibility. In particular, the accuser had claimed repeatedly on the witness stand that she did not coordinate her story with the first man, but text evidence obtained by the defense showed that, in fact, she had texted extensively with this man to consult about what they were telling police, and she explicitly discussed telling a false story. In the verdict, the judge said that she thought the 2 accused men had behaved badly, but not criminally. Now, there are a lot of things that could be said about this case which led to the disgrace of the entire University of Ottawa hockey team, including young men who had nothing whatsoever to do with the incident in question, some of whom weren't even in Thunder Bay at the time, but who were suspended anyway and cast under a cloud of shame. It also led to a public scandal at the University of Ottawa over the supposed rape culture on campus. Many decisions were taken in response to the case, and a great deal of public money spent to study and make recommendations about sexual violence at the University of Ottawa. And I have yet to hear anyone admit that the conclusion of the trial makes that years-long exercise in anti-male grandstanding look pretty lame. But lack of evidence has never mattered to feminist arguments about male sexual aggression and female victimhood. Let's look, for example, at the Crown's closing arguments in this case. And here I should mention that I'm drawing on a reporter's tweets of the case. And I should note that the statements were all originally in French, so they're in translation, obviously. The Crown had to rely on the hair-splitting rhetoric and infantilizing assumptions embedded in the feminist affirmative consent standard, which is now part of Canadian law. The defense position, in contrast, was based in legal common sense. The defense case was that the accuser's behavior clearly indicated consent. She did the same things with the second hockey player that she'd done with the first, and she acted in the same manner. In other words, she gave consent through her actions, even enthusiastic consent, according to witnesses. And she definitely never said no or indicated in any other manner that she didn't want to participate. But according to the Crown, none of these facts should save these two men from prison. All that is relevant to determining non-consent, according to the prosecutor, is what the accuser tells us about her state of mind. As he said, quote, "The notion of consent is not based on what other people saw or perceived. It is based on the subjective state of mind of the complainant." And further, quote, "It is not a defense to ask whether the complainant sufficiently expressed that she did not want to engage in a sexual act." I don't think one can exaggerate how illogical and unhelpful such premises are as a basis for criminal law, that sexual consent has nothing to do with observed behavior, and that the accuser need not say no for the sex to be deemed assault. Such a standard is contrary, in my opinion, to any common sense understanding of human sexual behavior. And it is also outrageous in its pretense that adult women can't be expected to be able to say no to sex they don't want, though these same women apparently should have the sole authority to send men to prison based on their after-the-fact reconstruction and reporting of an unknowable thing, such as their state of mind. Well, thankfully, the judge seems to have recognized the thinness of the Crown's legal case, especially given the fibs of the accuser. Nonetheless, the judge's verdict, which she read out in the courtroom on June 25th, was notable for the moralizing disdain she seems to have thought it appropriate to express towards the two accused men. Maybe she believed correctly that the not guilty verdict wouldn't endear her to her feminist colleagues, and therefore felt that a little preemptive man-blaming was in order. In her verdict, she objected to one of the defense lawyer's statements that the accused sought to, quote, clear his name. She corrected him to make a pointed distinction, saying, quote, "Perhaps they testified to defend themselves against the charges, but they will certainly never be referred to as having been gentlemen," end quote. In other words, the two men don't actually deserve to clear their names, ever. Well, what an interesting old-fashioned word to choose. Gentlemen? Haven't the feminists been telling us for decades that we shouldn't participate in the social shaming and stigmatization of lawful sexual behavior? Or is that only in relation to women? Perhaps the judge isn't wrong about these two men's behavior, but would she say the same thing about the accuser, that her decision to have drunken sex with a man she had just met through a dating app while his teammates were wandering in and out of the hotel room was hardly the conduct of a decent young lady, not to mention her decision to lay charges against them later on? We know she wouldn't. The judge's remark was a gratuitous act of feminist partisanship. The fact is, of course, as she well knows, these men have already been harshly punished over the past 4.5 years, far in excess of what non-gentlemanly behavior would warrant. Their hopes of playing high-level hockey were destroyed by a woman who played fast and loose with the truth. Their entire lives were put on hold while they endured the terrifying experience of the trial, and their names will, for years to come, be associated with sexual misconduct. The woman, whatever embarrassment she may have felt at the time, and I can imagine that she did feel very uncomfortable with what she'd done, well, she's been protected from public censure, her identity is still shielded by court-ordered anonymity, and she won't face punishment for perjuring herself on the witness stand. Despite her lies, in fact, newspaper reports continue to refer to her as the alleged victim. And right on cue, feminist advocates have come forward to complain about the verdict, not because it is yet another disgusting illustration of how easily feminists are led by their anti-male ideology to rally around a proven liar and perjurer, but because apparently the judge's failure to find the men guilty might make other accusers hesitate, and we wouldn't want women to hesitate to come forward. Quote, every time we see a high-profile sexual assault trial result in an acquittal, it sends women back 50 years, according to Julie Lalonde, an Ottawa-based women's activist. Quote, an acquittal like this is certainly not going to encourage more women to come forward, that's for sure. End quote. Well, we probably couldn't ask for a clearer statement of the feminist position. Note that. Every time we see a high-profile sexual assault trial result in an acquittal, it sends women back. Every time. Not just in cases where the proof of the man's guilt seems unquestionable. Not just in cases where the woman clearly suffered from a brutal violation. No. From the feminist point of view, any case that goes to trial should result in a conviction so that women can rest assured their word is law. Julie Lalonde's disappointment at the verdict, it's not surprising because she has a lot invested in men being found guilty of sexual assault. She's made male sexual violence her career. Lalonde was one of the community partners brought on to the U of Ottawa task force that was formed in response to the hockey scandal. Commissioned with much fanfare by the then president of the university, Alan Rock, the task force created a 55-page document titled Ending Sexual Violence at the University of Ottawa. And I recommend everyone take a look at this document, which is available online, if you can stomach the pages, the thousands of words of feminist anti-male sermonizing. The document took as a matter of faith that the hockey players were guilty, and it proposed sweeping recommendations to address what it called gender inequality and gendered violence at University of Ottawa. Even though its own survey showed that male students reported near equal and in some cases greater levels of harassment in comparison to women, including violence, threats of violence, and death threats, the report's recommendations focused overwhelmingly on men as perpetrators and women as victims. And amongst a litany of feminist-inspired proposals for sensitivity training and sexual violence prevention protocols and bystander intervention workshops and public awareness campaigns to keep on banging away at the myth that women on university campuses are constantly being victimized by men, the report approved something called empathy enhancement for men. This is on page 28 if you want to take a look. That, among other things, teaches men to view male sexuality from a feminist perspective, i.e., as always at least potentially harmful. That men have often reported feeling shamed, stigmatized, stereotyped, and collectively blamed by these kinds of approaches is, of course, never mentioned in the report as a concern. And not once in this voluminous report is the problem of false allegations raised. Not once do we hear about the terrible harm that false allegations cause to men, including not only ruined careers and permanently damaged reputations, but depression, self-harm, suicide, physical assault, and murder. Not once is it suggested that women have any responsibility in sexual interactions to communicate clearly with men. Not once is it suggested that women should be taught the difference so they don't confuse the two between sexual assault and just plain bad sex they didn't enjoy for a variety of reasons. Not once is it mentioned that women should not allow themselves to be talked into charging a man with sexual assault out of jealousy or hurt pride or embarrassment or regret or just plain meanness, though we men's rights activists can provide plenty of examples of women who have done precisely that. Not once is it mentioned that, contrary to feminist myths, women do lie about sexual assault and that our culture needs to emphasize more clearly that lying about it is a despicable crime. Of course, not once do the report authors acknowledge what I believe, which is that we live not in a rape culture, but in a cry-rape culture in which women are repeatedly encouraged by feminist authorities to reinterpret their experiences as assault and to make allegations against the men they chose to be sexual with. It's ironic that empathy enhancement was one of the feminist practices mentioned in the task force report, the obvious implication being, of course, that many men lack empathy for women's pain. I've found through many years of speaking with men and women that the opposite tends to be true. Most men are repulsed at the thought of causing any kind of harm to women. Women, on the other hand, are quite frequently unable to recognize harms to men at all. And no wonder, because they've been told over and over again by the Julie Lalondes of the world that they don't have to.
Thank you for watching. If you enjoyed this video, please support us on Patreon. If even half of our subscribers gave us $1 per month, we'd be well on our way to creating more and better content. And don't forget to subscribe to us on Studio Brûlé.